something is happening to your right to go to court, and almost nobody is talking about it. This video will explore a quiet change in the Canadian justice system. Across Canada, many cities are quietly replacing the traditional court process for bylaw tickets with administrative penalty systems, or APS. While APS sounds simple on paper, we need to look closer at what this actually means. Under the traditional court system, if the government accused you of violating a bylaw, your case went before an independent judge in an open court. The government had to prove its case, evidence could be challenged, and procedures were transparent. This system reflects the rule of law principle. Public authorities must exercise their powers according to law, not arbitrary administrative discretion, as confirmed in cases like Roncarelli versus Duplessis. Administrative penalty systems change this structure. Instead of court, the municipality issues the penalty and appoints someone to review the matter digitally. There is no hearing, and the application for review occurs online. The process is administrative, not judicial. This creates a conflict within the system. In effect, the body issuing the penalty is also operating the system that reviews the penalty, raising questions about independence and impartiality. Supporters of APS argue that it reduces court backlogs and speeds up minor disputes. Critics, however, argue it's a shift away from independent courts toward internal administrative enforcement systems run by the issuing institutions. This quiet structural change, a hidden shift in Canadian municipal justice systems, is already occurring in multiple Canadian municipalities. Most people don't realize it because it happens quietly through municipal bylaws and procedural changes initiated by administrative staff. The core issue is whether a penalty is reviewed by a fair, public, impartial, independent court or an internal, quiet administrative system inside the same issuing system. This question goes to the heart of the rule of law, and Canadians deserve to know the answer. A major shift is underway across Canada. Traditional access to courts is increasingly being replaced or restricted. These changes reduce a fundamental protection: independent courts reviewing government action. One action step is to identify where access to courts has been replaced. Examples include administrative penalty systems, municipal digital review replacing judges, internal ticket reviews, and online-only internal dispute systems. In several Canadian cities, including Toronto, Ottawa, Edmonton, and Calgary, municipal administrative penalty systems have already replaced traditional bylaw prosecutions that previously went through the courts. The APS process involves the municipality issuing a penalty, the person filing a challenge digitally, the municipality submitting a response internally, and a decision issued electronically. There is no courtroom, no judge, and no hearing. The dispute is decided through an internal administrative review process rather than the courts. Importantly, most citizens were never informed that this structural change occurred. Another action step is to document administrative barriers. These include mandatory virtual hearings, digital-only filing, complex online registration, administrative screening, adjudicators appointed by the issuing body, and internal appeals rather than independent court review. Individually, these barriers may seem minor, but collectively, they can create a system where access to independent courts becomes increasingly difficult. Citizens should demand legislative authority. Ask, what statute authorizes this system? Where does the law permit the replacement of court proceedings? Who authorized the removal of court oversight? If the authority cannot be identified, the action may be ultra vires, meaning beyond lawful powers. When challenging municipal APS systems, remember, there is no hearing and the process is entirely digital. The person challenging the penalty may not receive full disclosure of the evidence. Enforcement officers submit information internally, and that evidence may appear for the first time in the final decision. Judicial review remains one of the most important safeguards against unlawful administrative action. In many APS systems, there is no hearing, the process is digital, and the person challenging the penalty does not receive full disclosure of evidence. Also, enforcement officers submit information internally, and evidence may appear for the first time in the final decision. The fourth step is to demand a right to a hearing before a decision-maker who has independent judicial authority. Demand a right to fully disclose and challenge evidence, and the right to a physical court appearance. In conclusion, we need to speak up about these quiet changes to our justice system. The right to have disputes heard in an independent court is too important to be lost by a quiet administrative process.